Hi, I'm Rob Johnson from the law firm of RDJ Law Offices, and today I'm going to explain about the Nevada Asset Protection Trust, what it is, how it works, and how you can protect your personal assets from future judgment creditors. And what the Nevada Asset Protection Trust actually is, it's statutory. It comes under our Nevada Spendthrift Trust Act, which is actually Chapter 166 of the Nevada Revised Statutes for the book people who want to look that up and read about it. But the Nevada Asset Protection Trust was created by the legislature specifically with the intent to enable individuals like you and me to be able to plan in advance so that you can protect your assets from future judgment creditors in the event that you get sued. And one of the most common things that everybody has to deal with, I see quite often, is a car accident. People get into car accidents all the time. That's a classic example. It could be a breach of contract or future financial crisis. As long as it's something that comes up after you've established the trust is designed to protect those assets from those types of judgments in the event you lose your case when you get sued. Now, in terms of protecting personal assets, we're talking primarily about your home, your savings accounts, your investment accounts, non-retirement investment accounts, stock investment accounts, mutual funds, those types of things. Those can all be protected in the Asset Protection Trust. And to start with, in terms of the trust itself, again, it comes under the Nevada Spendthrift Trust Act. Spendthrift trusts are actually not new. They've been around for hundreds of years. Every state, I believe, has a spendthrift trust law. But most states, other than Nevada, that don't have an asset protection trust, spendthrift trust statute. They're the old traditional spendthrift trust. Now, there are some other states, I can't remember the exact number, 15, 16, maybe more now, other states that have a similar asset protection trust law. But I believe that Nevada leads the pack on having the most protective and favorable provisions built into the trust statute. So the spendthrift trust, if we know what the traditional spendthrift trust is, it helps us to understand what the trust is, how it works, and how it provides the protection that it does. So without boring you to death, a little quick rundown on traditional spendthrift trust. The traditional spendthrift trust was actually not designed to protect personal assets from your own judgment creditors. What it was traditionally was an opportunity for someone who had somebody else that they wanted to take care of and provide for. And the classic example is a parent that has like an irresponsible son or maybe daughter. The parents want to take care of the son or daughter to make sure they have sufficient to live on, they've got food to eat, clothes to wear, and a place to live. So they can set up in that traditional scenario a spendthrift trust to provide for that person as the beneficiary. But under those traditional spendthrift trust laws, you couldn't set up a spendthrift trust for your own benefit. It had to be for someone else's benefit. Under our Nevada Spendthrift Trust statute, that was one of the revolutionary things. Back in 1999, the legislature decided that they wanted to create an avenue for personal asset protection. And what they ended up doing was going back to our Spendthrift Trust law that was already on the books. In fact, it was in our original set of Nevada statutes. And they made some serious revisions to that to make it into what it is today. Now, our Spendthrift Trust law specifically says that you can create your own spendthrift trust for your own benefit. It even specifies that you can be a trustee of your own trust, even if you're the beneficiary, and you can still protect the assets that are in the trust because the law says that. So in any case, again, that's the quick big picture. Now, the law says that if you're going to be the trustee and the beneficiary of your own spendthrift trust, you do have to have a co-trustee that has the authority to exercise the discretion over whether or not to authorize a distribution out of the trust to you as the beneficiary. And that's the only intrusion, really, that the law requires of that distribution trustee. If you're your primary trustee, the law allows you to stay in control of your own assets. You can buy, you can sell, you can trade, and you can invest the assets that are in the trust without any involvement of that co-trustee that I call a distribution trustee, by the way. So that's the structure of the trust. The trust law is very protective, and it specifies that if someone has a judgment against the person that transferred assets to the trust, and it's a transfer issue, and it's a shortened statute of limitations for fraud is basically what it is. It says that a judgment creditor, if they want to bring an action after something that's been transferred to the trust, they have to bring that action within 2 years from the time of the transfer if it's an unknown creditor. After that 2-year period comes and goes, they can't bring an action at all. Prior to the end of the 2 years, that action has to be for fraud, and they have to prove that it was a fraudulent transfer as to that specific judgment creditor at the time that the transfer was made, and they have to prove that by clear and convincing evidence, which is a higher legal standard than the normal civil standard. So it's very difficult. It has to be fraud only. And if it's a known creditor, again, this is not designed to protect against creditors that you have now, but if it's a known creditor or claimant at the time of the transfer, the law says that they have to bring that action as to that thing that was transferred to the trust either within 2 years from the time the transfer was made or 6 months after they discover the transfer, or reasonably should have discovered the transfer. After that time, their time comes and goes. And it says that if the transfer was made on the public record, like real estate, say you transfer your home to the trust, that's a transfer on the public record, that imputes to that judgment creditor actual knowledge of the transfer, whether they knew about it or not in actuality. So once that time comes and goes, what's in the trust is very protected. Very solid. You have control over the assets, and it does the same things that a estate planning trust would. So this takes care of your estate planning side of things as to these assets. The trust will serve much like a will or a living trust. It'll spell out in the trust who gets what when you die, and that'll all happen without any court involvement. In the trust document, you specify preferably one or more successor trustees, so after you pass away, the successor trustee becomes the trustee of the trust, and they're bound to follow the direction that you've given and sell the assets and distribute in equal shares to your children or to charity or however you specified. You've got a lot of flexibility on how you build the plan of distribution on death. So anyway, that's the basic rundown on the Asset Protection Trust. Again, I'm going to do some other videos that will address the business, people that have businesses, and also real estate investors on what the best thing to do is for the real estate investors. But one thing to think about in your personal trust, you want to have only things that won't cause the trust to get sued. So you don't want to put your car into the trust because the cars get into accidents and the trust might get named in that accident. You don't want to put rental properties into that trust. Just those things that are not going to cause a lawsuit. So that's what the Personal Asset Protection Trust is designed to do. Thanks for watching.